hope you all are doing well. This is Ms. Shivangi Sinha, Assistant Professor, New Law College, Bharati Vidyapeeth, Dean to be University, Pune, and Faculty Coordinator of Madhyasthta, the ADR Cell. I welcome you all on behalf of our college and our cell. Madhyasthta is a student-driven cell established by New Law College, Bharati Vidyapeeth, Pune a year ago. Since its inception, the cell has tirelessly put in efforts to bring to its students unparalleled information pertaining to the field of ADR. In August, the cell launched its one-of-a-kind venture entitled Global Initiative for Alternative Dispute Resolution Awareness, GIADRA, an oracle for ADR. Through this venture, Madhyasthta aims at creating a single platform that brings together all the ADR professionals across the globe to impart the knowledge of ADR and make it a more prevalent practice. Dear viewers, it is a great pleasure for me to introduce our speaker for today's session, Mr. Tariq Khan, who is going to speak to us about the most famous Vodafone case. Tariq sir is an alumni of Jamia Millia Islamia, Faculty of Law, and currently serves as a principal associate at one of India's most reputed firms, Advani Co. Sir holds great expertise in international and domestic arbitration. Recently, he was recognized as the youngest BW Legal 40 under 40. We are pleased and honored to have you with us for today's session, sir.
No?
Yeah.
So, yes, sir, we'll be starting the session now. So before talking about the case at length, could you please tell us about the brief history of the case, which was a decade-long battle?
So the dispute between Vodafone and India is actually a very interesting dispute, which has been going on for almost a decade now. So this started somewhere in May 2007, when Vodafone invested in Hutchison SR Limited, which was based out of, I think, Cayman Island, and an investment of approximately $11 billion was made by Vodafone to get 67% stakes in the company. So what happened the moment this investment took place, the Indian taxing authorities, they issued a demand notice, a tax notice to Vodafone, stating that since it's a capital gains tax and you will have to pay this tax. Now this demand notice was challenged by Vodafone before the Bombay High Court by way of a writ petition, wherein Bombay High Court dismissed the writ petition eventually because they agreed with the taxing authorities. However, the stand of the Vodafone was that this is something which is not happening in India. There's not a transaction which is taking place in India. It is not. There's no territorial jurisdiction also of the Bombay High Court in relation of the taxing authorities. That's the main contention which was taken before the Bombay High Court. Subsequently, the matter then went on to the Supreme Court, wherein the Supreme Court agreed with Vodafone's contention. And the matter was then, decided in favor of the Vodafone.
Thank you, sir. Proceeding further, my second question is, when Vodafone approached the Supreme Court of India against the High Court, what was the Supreme Court's decision in this regard?
So the Supreme Court said that the offshore transaction in the present matter, it's a bona fide transaction, and it's structured as a proper FDI investment. And Supreme Court emphasized and gave clarity to the law. Supreme Court realized that it is very important to attract FDI and gave a very positive message to the international community at large that India is open to investments. And as long as your investments are going to be honest investments and there's no fraud involved, then we'll be happy to give you a smooth and ease of convenience will be there. So Supreme Court of India, I think it was an excellent judgment. And in my view, the dispute should have ended then and there when the Supreme Court clarified that the demand of the Indian tax authorities, approximately 22,000 crores, was unjust, and that Vodafone should not have done it because there was no territorial jurisdiction, because it was an offshore transaction and purely made in true spirit of an honest and bona fide FDI investment. So that was the decision of the Supreme Court.
Thank you so much, sir. So as you know that there was the retrospective amendment brought down in Finance Act in 2012. So what was that amendment that was brought down, and how did it affect the whole Vodafone case?
So generally what happens is when the Supreme Court decides an issue, there's an end to it. There's a finality attached to it, and it's not open for discussion. But interestingly, in the Vodafone case, what happened that when Supreme Court decided this issue, the government of India brought I think, late Finance Minister, Mr. Pranab Mukherjee, brought this amendment to the Finance Act, wherein they said that now the Indian tax authorities could tax companies of the previous gains which had happened earlier, and tax could be applied retrospectively. So this was the issue, and in a way, it was done to circumvent the decision of the Supreme Court, wherein the government authorities could now again tax Vodafone, and the burden again fell on Vodafone. So in spite of winning in the Supreme Court, the demand still stood. The 22,000 crore demand came back to life because as per the amendment, the taxing authorities could now do it this way. So yeah, that was the retrospective demand.
Thank you so much, sir. Moving further, the next question is who invoked the bilateral investment treaty signed between the countries India and Netherlands?
So this treaty was signed in, I think, 1995, and this was India-Netherlands Treaty, BIT, and Vodafone invoked this BIT. So before this, there was a lot of negotiation happening between the parties. It is not the case that between 2012 to 2014, there were negotiations taking place. Parties were trying to amicably settle. However, in 2014, when negotiation finally failed, now Vodafone decided to make this an international issue and took up this matter to PCA by invoking the BIT, India-Netherlands BIT.
Thank you, sir. Moving ahead, sir, could you tell us about the Arbitral Award rendered by the PCA?
Okay, so essentially Vodafone's argument was, I think I missed it, Article 4.1 of the BIT, which talks about fair and equitable treatment. Vodafone said that it was entitled to the same, and that it includes the government should have provided a stable, environment to do business to Vodafone, which was not done. So in a way, Vodafone alleged before the PCA that there was a violation of Article 4.1. Fair and equitable treatment was not given to the entity. Now the award came. I'll read the interesting part of the award. So of course, the unanimous award is in favor of Vodafone. The tribunal felt that India's demand to tax retrospectively was unfair, and it was against the norms of fair and equitable treatment. So the tribunal has said that Vodafone was entitled to fair and equitable treatment under Article 4.1 of the BIT. And also the tribunal has held that India's Supreme Court had taken a decision. And then it was, in view of that, they said that it was not open for the tax authorities to go into that question again by bringing about a retrospective tax. Also, there was very interesting, I think cost has been awarded in favor of Vodafone, I think, which is approximately 40 crores, and India's claims have been dismissed. I will read the relevant excerpt, which I quoted. The respondent's conduct in respect of the imposition of the claimant of an asserted liability to tax, notwithstanding the Supreme Court judgment, is in breach of the guarantee of fair and equitable treatment laid down in Article 4.1 of the agreement, as is the imposition of interest on the sums in question and the imposition of penalties for non-payment of the sums in question. Now, this was the finding so far as dismissing the claims of India was concerned. Now, coming to the finding where 40 crores as partial compensation was awarded to Vodafone as cost, the tribunal held that respondent will reimburse to the claimant, that is Vodafone, sum of 4327294 euros, or its equivalent in dollars, being 60% of claimant's cost for legal representation and assistance, and 3,000 euros, or its equivalent in US dollars, being 50% of the fees paid by the claimant to the appointing authority. So this was the decision of the tribunal, wherein the claims of the Indian government were dismissed, and the partial cost was awarded in favor of Vodafone, which is approximately 40 crores.
Thank you so much, sir. So as we know that India has been looking forward to making developments in foreign direct investments. So what do you think that would be the implications of this case on FDI in India?
So in 2014, India, as per World Bank ranking, was 142 in ease of doing business. Now it is 63 in 2020. So yes, we've done a good job, phenomenal job. The government's initiative, of course, is to attract more and more investment. But I think that this judgment will play a very important role. And in fact, in one of my articles recently, I had written that Vodafone will impact a lot of other BITs which are pending on similar issues, and many matters are pending. Similar matters are pending relating to retrospective taxation before tribunals. So this decision is definitely going to impact them all. And yes, it can be argued by a party that this will be a very this matter should be challenged, and because it is going to affect all the future investors investment, also because they will also accordingly plan their taxing, and they will get an impression as to how Indian authorities are going to tax. But I feel that for foreign investment, it's important that we give them a convenient environment, a comfortable place to do business. Only then the investors will be interested in investing their money. So when you're looking at investment like trillions of dollars in your country, and that is the vision of the government, I feel that we must give a very positive message, the one which was given by the Supreme Court of India in the Vodafone matter in 2012, wherein they said that they encouraged FDI and said that India is actually looking for investment and bona fide, so far as the investment can show that it is a bona fide investment, we will not interfere. We will not make it difficult for you. So I think that smooth uh, platform must be provided by the government as well as the Indian courts, and we should not get into the technicalities and should not give such we should not take such a regressive stand where we are taxing entities so that they'll be scared of investing in India. So I think that's my take on FDI in India about the Vodafone decision.
Thank you so much, sir, for covering all the aspects of the case and its impact in detail. So recently, Solicitor General of India recommended the government of India to challenge the Vodafone PCA award. So what are your views on the same?
So like I said, I feel that this was an opportunity for India to in fact prove that to tell the international community at large that we are actually trying to make arbitration regime more robust, and we are trying to give a very positive message that we will not be challenging awards which are reasoned awards. So in a lot of PSUs, public sector undertakings, we've seen they have a habit of challenging each and every award, whether it is a reasoned award or not. So I mean, that is something, this practice should have been discouraged. And in fact, in the article which I was mentioning about, I have written that Indian government should not have challenged it, though the learned Solicitor General has said that they will be challenging it. But I think that there are very slim and thin chances of succeeding before the Singapore courts, because in the past, what we have seen is that Singapore does not interfere and has not interfered with such matters before. Plus, the fact that the Supreme Court had put an end to the controversy in 2012, gave a detailed reasoning, and differentiated between tax avoidance, tax evasion. I don't see any point, going further and trying to exaggerate it a little more. Because in any case, there are, in my view, respectful submission, there are not high chances of India succeeding. So if the decision was not to challenge it, it would have given a very positive message to the international community that, look, we are not going to challenge it, we are accepting it. So investors would have felt more happy about it, and they would have felt that, yes, Indian government is more stable in terms of and more investor friendly. So yeah, that's my take on this.
Very well said, sir. Sir, could you tell us about your views upon the ADR mechanism in India?
So current mechanism, the government has taken great decisions recently. Of course, the amendment of 2015 was a blessing in disguise. And I think a lot of important changes were made. And now we have come up with 2019 amendments. Some of the provisions have not been notified. One specifically being the Arbitration Council of India. We are yet to see how it will be implemented and how things are going to shape up. It all, at the end of the day, depends upon the implementation of the Act. However, I feel that currently we need to make it more robust, because India, we have seen that more than 90% arbitrations are ad hoc. And unless we adapt the practice of being institutional arbitration and encourage that practice and promote it. Because I think there's a lack of awareness. If we compare with our other jurisdictions like Singapore and Hong Kong that are making huge progress and they are becoming hub of international arbitration. The reason is that institutional arbitration is more organized and people have more faith in that kind of arbitration rather than ad hoc arbitrations. So unless we do away with the practice of ad hoc arbitrations, Perkins was an excellent judgment, which of course did away with the practice of appointing unilateral appointments of arbitrator. And I think that the practice of appointing only judges as arbitrators must stop. We must get others on board. That is very important. Young practitioners should also be encouraged because, we should not limit the pool of arbitrators. That's one issue which I see. Apart from that, I think that if you're looking at investments, we need to increase more and more investment. India is largely dependent on agriculture. I feel that we need to also focus on infrastructure, supply, oil and gas. I think these are going to play a very important role because if you focus on these sectors of the economy, you're going to get a lot of investments in trillions of dollars, which will eventually generate a lot of employment. And of course, a lot of work for all of us arbitration lawyers. But we need to understand as stakeholders that we should not challenge each and every award. We should not try to make arbitration like litigation. And some duty is cast upon us, of course, as stakeholders to ensure that we tell our client honestly rather than, trying to get more and more work from one client. We should try to be honest so that when there'll be more work and if the arbitration regime is more robust, automatically more and more work will be generated. So yeah, that should be the endeavor of the stakeholders.
Thank you so much, sir, for explaining it so well. So at the end, what I would like to know from you is like, what do you think is the future of arbitration in India? Like, what all do we need to do in order to make arbitration as a preferred way of resolving disputes in India?
I think that this already got covered in the previous question, but I'll just briefly point out. So, like I said, briefly, I'll put it. One is that let's just do away with the practice of ad hoc arbitrations. We need more and more good institutions, and not just institutions. We need better infrastructure. We need to compete with jurisdictions like SIAC. So, if you see that in Singapore, we have Singapore International Arbitration Center. They have grown almost 300% in the past 10 years. We need to take examples. We need to be better equipped in all sense, and there should be a lot of awareness, and there should be some kind of endeavor to promote it, and that has been, the government is trying that. But at the same time, I think equally we need to provide a safe environment for investment to the investors, because at the end of the day, it all depends on how much investments we are getting. So the recent BIT model, if you look at, I think that it was discouraged by a lot of international experts, wherein India terminated almost 58 BITs. So I think we need good judgments also. Recently, Vedanta was an excellent judgment, a very positive step in the right direction, wherein the Malaysian court's award was enforced against, I think, I am forgetting the name of the entity by us. So the Vedanta, it was in favor of Vedanta, of course. So I think we need to set more such precedents, and there should be a continuous practice. There shouldn't be that two good judgments and then one bad judgment, because one bad step will take you 10 years back. So you need to always try to be consistent in the approach. So I think Indian courts and government will have a very important role to play in shaping up the future of arbitration in India.
Thank you so much, sir. Thank you so much for explaining the case so well and giving your thoughts on how India needs to work towards making arbitration a preferred way of dispute resolution and bringing in developments for the same. I'm sure this video will surely benefit a lot of students to understanding the case and through your perspective and benefiting from the same, sir.
Thank you. Thank you so much.
I, on behalf of Bharati Vidyapeeth, deemed to be University, and Madhyasthta, the ADR Cell of our new law college, extend a heartfelt thanks for this incredible session and for being part of our initiative. A big thank you, sir, for providing us with your valuable insights regarding the Vodafone case, the field of arbitration and its future in India. I'm sure the audiences will be greatly benefited from it. Further, I would like to take this opportunity to express my gratitude to our Principal in Charge, Dr. Bhagyashree Deshpande ma'am, for providing her constant support and guidance throughout this initiative. Lastly, I would like to thank all the students participating today. With this, we come to the end of today's session. Have a great day.